Hi, everybody. Welcome to the Addsure YouTube channel once again. It's really great today. I've got a very exciting guest. I've got Veronica Bhengu from Confiance Solutions with us, and very exciting stuff. Veronica, great to have you on the show with us.
Thank you so much, Mike, for the invite. I'm also very excited to unpack a few details with you. Thank you very much.
No, great. I'm very excited because I think you fulfill a very much needed service in our part of the world. I have many clients out in sectional title around the country, and yeah, I see that you do administration. It looks like you do a bit of EMA work, and a few others. So tell us about it. First of all, tell us about yourself. Where did you come from? What is your background? I understand that you're an attorney and you work with, quite closely with the Stratafin Group. Tell us a little bit more.
Okay, so my name is Veronica Bhengu. I am admitted attorney by profession. So I studied an LLB, I studied a BCom law degree, and I did my board exams, and I was admitted as an attorney in the year 2021. Yes, so that's my profession. And I started working at Stratafin in October of 2020 as a legal officer. So I was just assisting in the legal department. And then compliance became this baby of mine, of which I delved into and learned more about sectional title compliance. And that grew to being a compliance officer at Stratafin. And then I was promoted to one of the directors of Confiance, and Confiance Administrative Solutions is a sister to Stratafin. So Stratafin 100% owns Confiance. Yes, so that's where I come from. And Confiance Administrative Solutions has a few services, and one of our major services is sectional title administration. So we get appointed by the court in terms of Section 16 of the Sectional Title Schemes Management Act, where we will then administer and rehabilitate schemes that are distressed. We apply a rescue plan, a rehabilitation program, if you might, for these schemes that have issues such as financial distress, infighting, no management, no leadership, no decision making, lack of maintenance, and general non-compliance with the Sectional Title Schemes Management Act. And also at Confiance, we have a municipal department that assists us with municipal queries and discrepancies on sectional title counts. So, for an example, it happens that the municipal council will misinterpret your scheme for a single standing household, and we know that there's a rates and tariffs applicable for sectional title units and freestanding units. So Confiance in assists with correcting those discrepancies and correcting that for the body corporate. So those are one of the a few of the services we provide, and also general consultation services with regards to compliance elements. So many self-managed buildings don't understand the necessary requirements to call an AGM. What is a special resolution? So we assist even body corporates that are not self-managed, that have a managing agent, trustees who want to know more information, education, and just enhance their knowledge on sexual title and management and compliance. And we assist with that.
No, that's great, Veronica. You've answered probably 3 or 4 of my questions in one shot there, so that's fantastic. Um, and very, very easy for me to summarize nicely. So I'm going to ask you in a nutshell then, if I have a client, for example, a body corporate where the trustees can't get along, 2 sets of trustee type situations, 2 sets of owners, and they need a professional to step in. So, would you come in as an executive managing agent, or in some cases, would you suggest being an administrator for the scheme? In a case of being an administrator, you would probably need to be appointed by court. How would that work? Can you run us through that scenario?
Yes, yes. So if a scheme comes through, and normally the problems piggyback on each other, so it wouldn't be solely that you have a scheme that has infighting between two bodies of trustees. We'd kind of need to see the holistical picture, unpack all of the issues, and that will lean more as to what the necessary remedy would be. So in a situation where you have two sets of trustees, we'll need to unpack that might be just cleaning up compliance, unpack how the one body was elected and how the other body was elected. But if you have two valid bodies of trustees and that the meetings were called correctly, but just the timing in which they were elected doesn't make sense, then you have financial issues, you have lack of maintenance, then you have a distressed levy roll, then that would lead more to an administrator being appointed. I must say that at Confiance at the moment, we're trying to register with the PPRA for executive managing agents, trying to get our our exemption certificate, pardon me, in terms of Section 4. So we're still in the process of being compliant in that area so that we can assist clients that do need an executive managing agent.
Ah, fantastic. Now, I'm sure that's just a matter of dotting the I's and crossing the T's, because
Yes.
you, having met your team, really professional and experienced, and being with the Stratafin group, really one of the most experienced groups in the country.
Thank you, Mike. Thank you.
Being an administrator, you have to, in order to be appointed as administrator, the body corporate would have to go to court to go through that process, or can you just become
Yes.
an administrator? It's not just like being an EMA. There's a big difference, isn't there?
Yes. 100%. So with an EMA, you need a resolution, you need a special resolution to be appointed. And with an administrator, the court needs to appoint the administrator. So how that process goes is the Section 16 of the Sectional Title Schemes Management Act allows for an owner, a single owner, a creditor of the body corporate. So it could even be the managing agent who's been outstanding of fees. It could even be the local municipality, maybe who's disconnected this scheme, have it no payment arrangement. So various types of people or organizations can approach the courts to recommend that the scheme be placed under administration. And there's two factors that the court will take into consideration. The first point is what problems is the scheme facing, and then in the application you will then list there's infighting, there's a no levy collections, there hasn't been a maintenance, there's no 10-year maintenance plan, there hasn't been an AGM in past 2 years. And then the second element you need to satisfy the court is that the scheme is able to get rehabilitated. And that's where the Confiance model comes in, because in our applications we tell the courts how we will address these issues that the body corporate is struggling with. So in the application, the administrator will then be suggested to the court. It's not like one that the court will go find an administrator for you. The client or the owner, the person making the application must bring their candidate administrator to the court with their details so that the court can say, okay, I see the issues that the scheme is facing. I see the plan the administrator has. I'm happy with it. I'm granting the order. Or the court can say, I'm not happy with this. This doesn't suffice. Go back, amend your papers, and so on and so forth. But that would be the traditional procedure that an application for administration would follow.
Fantastic. That is awesome to hear. So it doesn't sound too complex. Tell me, can CSOS appoint or recommend to the court that a scheme, and has this been done before? Are you aware of it? I mean, if something is at CSOS, is it a common practice, or does it happen now and again that CSOS might say this body corporate needs to be under administration? We recommend, or you can take their recommendation to the court. Question mark. How does that all work with CSOS?
I haven't seen a situation where first here an application needs to be brought to court or to CSOS. I've never seen one where CSOS would say, here is an administrator. I've seen where they have EUA panel members, where they'd say, here's an exclusive executive managing agent, pardon me. I've never seen one where an application is brought to CSOS, then CSOS says, okay, here's an administrator. I've seen seen, however, situations where a court application to renew the appointment period of the administrator was declined by the court, and then the court directed CSOS to find a more suitable administrator. Yes.
Okay.
Yes.
No,
Yes.
fantastic. Okay, so I've been harping on the administration side, but I understand that that's one of your strong areas. So, hence,
Yes.
having done so, what other areas would you say, besides what you've told us already, that we should consider you for? In other words, you know, you're speaking to me today, but I'm going to share this with my clients. So a typical
Yes.
Addsure client, body corporate or portfolio manager, why should they pick up the phone and phone Veronica and say, Veronica, help us? Okay, we know
Yes.
we need you to do administration for us. We understand that you're going to be a managing agent at an EMA officially soon. One of the advantages I would say is that you're not actually managing agents, so as far as I know, and therefore there's a sort of arm's length so that you can work with managing agents, so you're not competing with them. Tell me more. Where can they find you, and
One thing.
why should they contact you?
Um, First of all, Confiance has a very, very experienced team. We have myself, I'm an attorney. We have our co-director who has over 30 years experience within municipal services. So that leans within our municipal service product that we have. We also have the head of municipal services who also has a lot of experience within sectional title municipal queries. So this is very, very specialized. And each and every problem, and I've just mentioned one that is common where the tariffs are not correct, that they can assist you with. If you can't get through to the council, maybe you want to settle your debt, you want to enter into acknowledgement of debt, you'll be dealing with seasoned professionals within this industry. And another reason why I would urge managing agents or trustees to give us a call is that we at Confiance have a harmonious way of operating. If we have a scheme that is experiencing these problems and the managing agent is like, I don't know how to fix this. That's where our skills and expertise come in as Confiance. And if you do elect to put the building under administration, we will work with you as the managing agent, and us as Confiance will step into the shoes of the trustees. And then another reason to give us a call is that our slogan is confidently compliant. So we know the law and we understand the law, and we can help you be compliant. Like I said, whether it's issues of just brushing up areas of compliance, whether you want to raise a special levy as a managing agent and you're not sure on the resolution type or the notice period, you can call us, the professionals, and we'll give you the templates, we'll give you the resources to assist you to do what you need to do as a managing agent. Yes.
Veronica, thank you very much. That really sums it up nicely, and fantastic. I look forward to working with you more going
Thank
forward.
you.
And yeah, here we go, guys. Contact Veronica. Don't forget, like this video clip. Don't forget to share this video. Veronica wants to be shared far and wide, and then of course
Yes.
subscribe to our YouTube channel. Right. Thank you very much, Veronica. See you
Thank
again.
you, Mike. See you.